Hi, everyone. Welcome to another edition of the Sfarim Chatter podcast. On this episode of the podcast, I'm going to be joined by Professor David Fraser, who is the Professor of Law and Social Theory at the University of Nottingham. And we will be discussing his book, fairly new, a few years ago, which is Anti-Shechita Prosecutions in the Anglo-American World from 1855 to 1913. So thank you, Professor Fraser, for joining me.
Thank you for having me.
So start off, why don't you tell the listeners a little bit about yourself and your background?
Okay, I am, as you said, a law professor. I'm Canadian by birth. I've taught in Canada, the US, Australia. Now I'm in England, so I've had a fairly peripatetic academic existence. Most of my research is in relation either to Jewish legal history or in relation to law and Nazi Germany.
So I guess that brings up the question. So how did you get into Shechita and anti-Shechita? Why pick this?
Well, I'm sort of aware and conscious of the sort of ongoing controversies around this question. And I came across a reference to the Halifax case, which starts the book, when I was researching another project. And I thought, and so I just read a little bit about it, and it said, this is the only case where this has ever happened. I thought that sounded a bit interesting. And then as I read more about it, I thought it sounded a bit wrong because I kept coming across other cases where, exactly the same thing had happened. That is, people were being prosecuted. And so that was sort of the birth of the project. It started from a very small legal history case from Nova Scotia about a small, relatively obscure Jewish community. Thought, well, that would be an interesting self-contained topic. And then it just sort of became much less self-contained.
Right, and I'm sure we'll get to that case a little bit. It's a really interesting and unique case. So I guess we should then start off with the whole Shechita issue. I guess you could even start off and just explain what Shechita is. If those, I'm sure most listeners probably know, but we may as well just explain it exactly. And then from there, you can talk about the history of the anti-Shechita and how that, when and where that started.
Okay, well, it's the basic practice of killing animals for human consumption in accordance with Jewish law. It basically requires that an animal, in order to be consumed, must be killed with a single continuous strike of a knife, which has to be perfect by someone, the shochet, who's trained to do this. It's a very long and intensive theological and practical training period. And it cannot be done if the animal is injured, if the animal is ill, or if the animal is stunned, because stunning would inflict injury and therefore it couldn't be consumed according to Jewish law. And so the anti part of the story is, in the mid 19th century in England, and then in the US, Canada, Australia, the cases that I look at. It was sort of the moment of the arrival of, Protestant morality, of the notion that there was a Christian duty to protect the helpless creatures, who were, of course, and in no particular order, women, children, and animals. And so it was part of this notion that animal cruelty was a moral wrong, and it had to be stamped out so that we could live a decent, civilized existence according to a particular theological view of the world. And because it dealt with the notion that cruelty to animals was a bad thing, that it was immoral, in the very earliest days of animal protection and SPCAs and humane societies, there was a very significant Jewish presence in these organizations because, of course, not being cruel is part and parcel of, Jewish ethics. So what was interesting from that perspective was the way in which the sort of ecumenical early days of these animal protection societies sort of is lost in the history because soon they became foundationally and fundamentally Protestant in their view. And sadly, but not surprisingly, part of Protestantism carries with it today and historically, I don't think it's controversial to say this, a distinctly strong anti-Semitic attitude. And in relation to cruelty, this is, of course, translated, again, I'm not the only person who says this, bizarrely, but consistently, with some notions that Jewish people are obsessed with blood, that sort of Jews are bloodthirsty, that the Jewish religion sort of is caught up in things like blood and cruelty from, for example, that, the more infamous manifestations would be the blood libel, which has been with us for centuries. And then in relation to this particular issue, that the practice of killing, according to Jewish law, animals for human consumption is symptomatic and reflective of this Jewish bloodlust. That the notion that you kill by slashing an animal's throat and letting it bleed is somehow turned into something that's nothing more than a reflection of this innate Jewish cruelty. And so you have this combination of don't be cruel to animals, anti-Semitism, which then leads you to the way Jews kill animals for human consumption must be cruel because Jews are cruel. And look at the blood, and they don't stun the animal. And so this combination of theology and moral improvement led to this movement across a number of countries where, there was an attempt to criminalize the practice and to abolish it, essentially. That was the goal.
And you view this as it arose out of an anti-Semitic sentiment more than and they just kind of blamed it on being humane, more or less.
I'm saying that the two coexisted, that they could coexist without going after this particular method of killing animals. Because, again, in the early days, Jews were prominently part of anti-animal cruelty organizations. And then there was a perversion or a natural consequence of Protestant domination of these organizations, but there was a misassociation, which I think, and I argue in the book, was deliberate. And it was a deliberate combination of anti-Semitic beliefs with the notion that cruelty to animals is a bad thing, and people who are cruel to animals are bad and wicked. And, then the consequence is when you combine that, Jews are bad and wicked, look what they do to animals.
Now, I would mention, you said the SPCA, which is, you talk a lot about, we'll mention more, Societies for the Prevention of Cruelty to Animals. You said that, you also write in here, I thought this was interesting, quote unquote, that they claimed their sole aim was the protection of God's dumb animals, which I thought was the interesting wording. But, so clearly they didn't come out and say, well, hey, Jews are cruel, we're going to attack them. So what was their, at least public basis, what was their claim of why this was cruel, essentially? How did they decide this should be banned and illegal?
Well, I would give a slight correction. Some of them did say Jews are bad, and look how cruel they are to animals. Many, though, as you say, would make the famous claim, the infamous claim, the continuing claim, I'm not an anti-Semite, but. So there was this, I have nothing against the Jews, except they're cruel when they kill animals. So, these sort of ways in which these things were combined in all of these instances can be quite complicated. But, they very quickly took the view. And this was a view also because this was when they came with this notion of social progress. It was also the era of science and the entry of science into political and public discourse. And they were very keen to promote the idea that science proved that the most humane way to kill an animal, and indeed the only humane way to kill an animal, was to stun before killing. Because then the animal wouldn't suffer when it was actually being killed. And so there was, this combination of the moral good of society, Protestant theology with a very strong anti-Semitic motif, and science that basically, conveniently for the animal protection people, proved that the Jewish method of killing animals was in fact cruel. Science told them that. So they weren't being theologically anti-Semitic or personally anti-Semitic. It was just that science led them to the conclusion that the Jewish practice was cruel.
Also, interestingly, as you keep mentioned a few times, that it's a Protestant kind of anti-Semitic thing. I mean, these countries were, I guess, at least at that point, predominantly Protestant. So did you look at Catholic countries, this didn't happen, essentially? Not that they were not anti-Semitic and not there are other issues, but these anti-Shechita issues didn't arise, really?
Well, they did arise in Europe. So in Poland, for example, which is, perhaps the quintessentially, but for, Italy and the Iberian Peninsula, the quintessentially Catholic European country, there has long been a history of attempts to ban the practice. That's very obviously grounded in Catholic theology and Catholic anti-Semitism. So there's Christian anti-Semitism of different varieties, and the places where I was interested in looking at, which are the English-speaking countries, there was this movement. But obviously, if you look in, for example, Germany, or you look in Switzerland, where you have both Catholic and Protestant, significant populations. So you wouldn't necessarily say, as a whole, the countries are either Protestant or Catholic, although they are by majority population Protestant. Those are the two countries that banned the practice in Europe. There's not much doubt that they banned the practice at the instigation of parties that were self-declared anti-Semitic political parties. So maybe I should say Christian theology, although in these instances it was Protestant theology.
Right. Now, in the instances that you look at, as you mentioned, mainly in the book, which are in England, Canada, the United States, and Australia, in all these cases, which we'll get to in a minute, were all the main overall issues and theological reasons, were they all the same? Do you see a similar vein running through all of them, even across different continents, or sometimes some of the cases had different, unique reasoning behind them?
Well, they all had particular, historical and local circumstances that surrounded them. And so, something like a rural community like Aberdeen in Scotland, where one of the cases took place, is different from London in terms of, just its geography, its history, its sociology, and the size and significance of its Jewish community. Those are differences. But throughout all of these cases, in all of these countries, there is this dominant theme that animal protection is a social good and the Jewish practice is cruel. And there's science. Science tells us that you can kill animals in a more humane way than by cutting their throats with a knife, blah, blah, blah. But there's also, in every case, in different ways, but in every case, there's a very strong presence of anti-Semitic motifs. And in many cases, just clear statements about, Jews are bloodthirsty, Jews are barbaric. They're, if they can't kill animals humanely, they should give up their religious practice. as blatant as that. And that was somebody, from Boston who said that. So they're all anti-Semitic cases, very clearly. And it doesn't take great detective work to uncover the anti-Jewish hatred and bias that's present because, in their own words, they condemn themselves.
Wow, that really shines through. So this is a lot of this what we've been discussing is really you discussed in the introduction, and then it kind of is woven throughout the book. But the book, as you said, is mainly a look at being, I guess, also because you're a law professor and a legal scholar, looks at court cases and the prosecution. But as I mentioned to you before we started recording, they're not, I'll term it this, not exactly like this, but they're kind of courtroom dramas. They're very interesting reading. It's very entertaining. You get to see, what was going on. And you start off each chapter. I mean, you could talk a little bit about this also, how you mentioned the community, whether it's in Halifax in Nova Scotia or it's Aberdeen in Scotland. You mentioned the Jewish community there, its history, and the players involved in each case. But I guess just start off, I don't know if you want to start off with the Halifax case, just to, explain the cases and go through and just talk a little bit about, these cases and what you saw in them.
Well, the Halifax case was where I started with this just by, happenstance and sort of as a product of researching another question altogether. And basically the Halifax is a port city. So it was when massive emigration of Jews from Europe started in the 1880s, 1890s, and then the turn of the 20th century. It was a place where many ships carrying European Jews stopped. It was the first landfall in North America. Many of the people who got off the boat, they moved on. They went, west to Montreal, or they went south to Boston or New York. But some stayed in Halifax. And by sort of the time of this case, which was 1913, just before the beginning of World War I, there was what we would call a significant Jewish population, significant enough that they had a synagogue. For many years, there was a smaller community, but they worshipped in private homes or in places made available to them by some of the local community, non-Jewish community. But then by this time, they had a synagogue, they had a rabbi who was also a shochet, and they were significant enough in terms of population and in terms of their, Orthodox belief. And that's, of course, the obvious other common denominators. These are all observant, what we call Orthodox Jews. And so there was a demand for meat that was, kosher, basically. And so they needed someone who was trained, who could kill the animal in the appropriate way and follow the legal procedures according to Jewish law. So there was a small community, but Nova Scotia is predominantly Christian. And it had worked, and particularly the city of Halifax worked by a kind of a silent compact between Protestants and Catholics. To some extent, it sounds a bit like New York. Police would be Protestant or firemen would be Catholics. And they would have a certain number of judges who could be Catholics and a certain number of judges who could be Protestants, etc. So that's how the society worked. So the Jews had their own community, but they were a minority group. And of course, the whole Victorian Gilded Age notions of social improvement and stamping out poverty, making sure people got an education as a way out of poverty, stamping out prostitution because it's a moral evil, that sort of affects the fiber of society. All of those things were going on. And one of the things that was going on at the same time was this notion of protecting animals from cruel treatment. And it's fair to say that this was part of a broader project, this particular prosecution in this case, because the Nova Scotia wanted to ban all slaughter of animals that didn't involve stunning. And it's also important to say that the killing of animals without stunning was a common practice at the time, not just, in accordance with Jewish law, but that's what farmers did. That's how they killed their animals. So it was part of this broader policy and goal. But in the end, what they did was they targeted the Jewish practice, and they sent an inspector and a veterinarian who would serve as a witness to watch the process. And as soon as the process was completed, they filed charges against Rabbi Levitt, who was the shochet and rabbi of the small community, for animal cruelty. And, things proceeded apace. He was, Russian. In fact, he was Lithuanian, but he's described as Russian. He come from what we now call Lithuania. And he didn't speak English. So his trial was a trial where a local member of the Jewish community had to act as his translator because he couldn't understand the questions and he couldn't answer the questions, which raises interesting issues about how fair the trial actually was. But when you look at the comments from the judges and the prosecutor, it's very clear that their minds were pretty much made up. And, they didn't want to hear about Jewish law. They didn't want to hear about thousands of years of Jewish religious practice. They just wanted to know that they didn't stun animals and that was cruel. And so he was convicted. Now, he also had the benefit of being represented by the best criminal lawyer in Nova Scotia, who happened, and this again is where things get complicated, who happened to be a Roman Catholic. So the judge and the prosecutor were both prominent Protestant Nova Scotians, eminent members of the legal community and of the Protestant elite, and their opponent, the defense lawyer, was a Roman Catholic. So you had the Roman Catholic representing the Jew and the Protestants representing good and moral behavior and, protecting the norms of a decent society in Nova Scotia. Eventually, the case went on appeal. And at this moment, the larger Canadian community had been energized, and that basically means Montreal. So Montreal at this time had the largest Jewish community, the longest established Jewish community, the wealthiest Jewish community, and a Jewish community that was aware of what was happening to Jews in other parts of the country. So they sent an expert to help with the defense and to testify about Jewish law in the appeal case. And they also, to a lesser documented extent, helped to get a professor from Dalhousie University's medical school. Dalhousie's the big university in Halifax, who was an expert in nerves and in the physiology of nervous systems, who basically testified that what the animal protection people testified was the thrashing about in agony of the cow once its throat had been slit was in fact nothing more than an automatic nerve reaction, and that as soon as the shochet's blade had crossed the throat and severed the blood supply to the brain, the animal was dead and didn't feel any pain. And so you have, in this Halifax case, all of the themes that you find in all the other cases. You have, the normative killing animals. We have to do it humanely. We have to be good Christian citizens on the one hand. And then you have the Jewish defense, which is two parts. One is the theological imperative, right? That is, if you don't kill animals in this way, they're not fit for human consumption, and so Jews can't eat animals. Thousands of years of Jewish law and of Jewish practice, and thousands of years of Jewish ethical concern not to cause suffering to human beings or to animals. That's just the theological basis. And then on the other hand, you have the scientific argument, which is killing without stunning, if it's done by the Jewish method, is not inhumane or cruel because the animal doesn't suffer. Beyond the original cut, the animal doesn't suffer because it's all swift. If it's done properly, the animal's nerves are severed and it feels no pain. And so you have this, it's cruel, and then, no, it's not cruel. Science says you have to stun. No, other science says the nerves are severed. So, lawyers are familiar with the notion of battling experts. And, you see this in all of these cases. You see the theological and the scientific on both sides. So each side mounts a theological case, that killing animals this way without stunning is cruel and inhumane, and these are God's dumb animals. And the science says, oh no, they thrash about and it's painful, and in order to avoid pain, they have to be stunned. And then on the other hand, you have thousands of years of theology, Jewish ethics, which prevent cruelty. And the science tells us that actually many of the methods used to stun are far more cruel than anything that Jewish practice would warrant. So it's either, and again, this becomes complicated, it's either not cruel or it's only as cruel as the method that you are trying to impose. So at a minimum, it's no more cruel. And at a maximum, it's not at all cruel. And these arguments get, conflated and they become problematic.
What was the outcome at the end of the day in this case?
At the end of the day, in this case, he was acquitted. And, based partly on the expert evidence by the rabbi. Unfortunately, there's no reasoned judgment. So we only know, from the newspaper accounts, as is the case in most of these instances. But partly on the basis of the expert theological testimony and partly on the basis of the expert physiological testimony. So again, it combined these, and he was acquitted, which wasn't, of course, always the case in other instances. Sometimes they were acquitted, other times they were convicted.
I believe the book has 8 cases, right? If I'm counting correctly, of various cases. Is there any other ones or another one that you want to mention or focus on specifically? You can.
Well, I would only say that, most of them have in common this, all of these overarching tropes and are not too difficult to discern anti-Semitic reason behind the process. I think one of the things that's particularly interesting and which manifests sort of clearly the way in which there's a synergy between the anti-cruelty movements and anti-Semitism is in the Aberdeen case in Scotland. The Aberdeen case in Scotland, there was Aberdeen, for those of us who are beef eaters, is the home of what is considered the best beef in Britain. And so there was a huge market, obviously, for beef, and there was a huge market among the Jewish community in London for kosher beef. And so the small Jewish community in Aberdeen decided this would be a good way to supplement our income. We need to get a trained shochet to come and to slaughter the beef according to the laws of kashrut, and we'll make extra money. And so they did. The first time the shochet did his job, the SPC and the local prosecutor were there to see what this was about. And again, as with the Halifax case, as soon as the process was over, they were charged with animal cruelty. Now, the more interesting aspect of this case that points to the sort of anti-Semitic reasoning and motifs in this case is that 2 people were charged. The first person who was charged with animal cruelty was the shochet himself, the rabbi. And the second person was the president of the local Jewish congregation, who was in attendance because this was the first time they had proceeded with this project. The president, Mr. Zamek, of the congregation, was not present in the room when the cow was killed. He was standing outside. He had absolutely nothing to do with the slaughtering process. He wasn't there. The people who were there were the Jew shochet and 3 or 4 other Scottish people, Protestants, Catholics, Christians, who were, slaughtermen assisting in the process, who got the animal ready for slaughter. The only people who were charged with animal cruelty were the shochet and the president of the Jewish congregation. Now, what do we glean from this? Well, the president, Mr. Zamek, wasn't even in the room when this happened. So how could he be cruel to an animal when he was, somewhere down the hallway, having nothing to do with it? In addition to which, the Christian Scottish people who were there helping in the killing of the animal weren't charged either. So the only two people who were cruel to the animals apparently were the Jewish shochet who killed the animal and the president of the Jewish congregation who was, yards away down the hallway. And nobody else apparently was cruel. So none of the Christians who were in the room were charged. And this was a pretty common theme in many of these cases, that the slaughterhouses, obviously, in most of these cases, were not specifically Jewish slaughterhouses. And so the people who were assisting in the process of preparing the animal to be killed were almost inevitably Christians. And almost inevitably, they were never charged in these cases. It was, it was the Jews. And that tells us quite a bit about what was going through the minds of the animal protection people in relation to their decision about prosecuting people.
Did you see a standard line of defense running through these cases? What was the standard defense to these charges?
The standard defense was, it's not cruel. And as, a supplement to that, either the scientific proof that it's not cruel, or the basic theological position that the Jewish religion forbids cruelty. In addition to the sort of the rules and the technical competence involved in the killing of the animal, there's the more underlying ethical paradigm that cruelty is forbidden. And so the argument that was always raised was, it's not possible that Jewish people involved in this process would treat an animal cruelly. It's not possible because that would be unethical in terms of Jewish theology. And it's also not possible because all of the acts that are described, which lead up to the actual killing, if they were true, and if they were attributable to the Jewish people involved in the process, would mean that the meat from the animal wouldn't be fit for consumption because it would be injured. And so obviously we wouldn't do this, both, for theological reasons, for ethical reasons, and just for the very practical reason that we are doing this so that members of our community can have meat supplied to them in accordance with our law. And that was the defense in every single case.
So it kind of was the same defense. Now, something that the book, like we mentioned, the book says in its title from 1855, 1913, the book does not focus on today's, kind of in the recent issues of anti-Shechita. So, I'm sure you have what to say on it. I don't know what you have discussed. Are they similar issues, and do you see it arising out of the same issue and then the same kind of charges still being leveled?
Well, one of the reasons that the book stops when it does is because, well, first of all, World War I came along and sort of things were, more important than prosecuting an occasional shochet for killing a cow. After that, though, the strategy changed, and the strategy became one of trying to get legislation passed to ban the process. And that had been the case in Germany. In Switzerland, they changed the constitution by plebiscite to abolish the practice. And this became therefore much more a political battle in that it was an attempt to lobby legislators to pass laws banning this form of killing animals for human consumption. So I wasn't really as interested in that. The modern day process of banning or attempting to ban, which we see we do see it in North America to some extent, but it's much more a European phenomenon these days. And you see it in countries, Scandinavian countries. Poland, for example, has had a series of controversial attempts to ban this. particular procedure. But most recently and most effectively, it's been Belgium where this has happened. And recently, the European Court upheld a Belgian ban on Shechita. And the motivation that it gave, in addition to the other theme that I'll come back to in just a minute, was that the Belgian legislation said you can't kill an animal for human consumption without stunning it first. And they recognized that this violated Jewish and Muslim belief, because one of the sort of emerging motifs in European practice is anti-Islamic agitation, as well as anti-Semitism. So perhaps on the issue of sort of attempts to ban circumcision and attempts to ban Shechita, Jews and Muslims in Europe actually have common cause, which is sometimes nice to see. But what the court in the recent Belgian case said was that, yes, the law bans killing without stunning, and that violates Jewish law, but it only violates part of Jewish law. So, they could still kill the animal, they just have to stun it. And the stunning would be illegal, but the killing they could still do, which, I mean, I don't know if it was because the lawyers representing the Jewish community were really bad in making their arguments, or if the court is being disingenuous in this. But, that sort of, it's obviously absurd to say that. It's obviously absurd to say, oh, it's only part of the process. Of course, they recognize that it is in violation of Jewish law and Jewish belief. But they still upheld it. And they upheld it because the Belgian legislation is framed very clearly in terms of the state's obligation to protect animals and to prevent cruelty to animals. So it's exactly the same. We have an ethical, moral duty to protect animals from cruel treatment. And you have this barbaric Jewish practice. And, they could just change. They could just stun the animal first, then kill the animal, and they would be acting in conformity with, all these wonderful ethical and legal norms, which is, it's just so tragically obvious, that sort of there's very clearly anti-Semitism that's motivating this. And there's even more foundationally in the Belgian case, there's a basic level of ignorance where the court doesn't even engage with it, just says, it violates Jewish law, but not so much, just a little bit. So it's okay. So if they want to kill animals with the shochet and the knife, they can do that. They just have to stun the animal first. So a little bit of like, hold your nose while you violate the law, and then everything will be okay.
Yeah, it's incredibly disingenuous. It doesn't even make sense, because they're basically ruling that Shechita is illegal, and too bad. You just
only part of it, though.
Right. I guess, like you're saying, maybe the lawyers did a bad job explaining, well, if part of it is, the whole thing is you did it the wrong way. Maybe that wasn't explained. They thought you just need to use the knife rather than a different way of slaughtering it. Yeah. I don't know.
Yes. That's basically it. As I said, I don't know if there are people who argue that this was just poor advocacy by the Jewish community in sort of explaining to the court exactly what was going on. But I think that it's the court being extremely disingenuous and trying to avoid, a blatant anti-Semitic decision, and just trying to come up with a decision that's anti-Jewish in its consequence, but isn't anti-Jewish in its motivation. Although, if you look at this and you think, okay, well, what is Shechita? It's sort of killing an animal that hasn't been stunned by, that's what it is. It's not something that's divided up into parts. And, again, along with, moves to ban infant circumcision and moves again in Poland and in the Scandinavian and Nordic countries to, ban Shechita, it's 2020, 21. 100 years after these cases, more than 100 years sometimes, 150, 200 years. It's the same thing.
Well, it's like you're saying. So I'm going to include a link to the book. Now, I will mention that the book is over $100. But you did mention to me that's maybe in a year or whatever. There will be eventually a paperback coming out, right? Hopefully.
Hopefully, yes. Hopefully. And, if people write to the publisher and say, I would love to buy this book, but it's too expensive, maybe consumer demand will drive them to make a more logical marketing position.
Right, it is Academic Studies Press. So that I will include that. And finally, I will ask you, did you write previous books also related to other topics? And are there any other future projects related to, not just law, related to, Jewish related topics?
I am a lawyer. So it's, for my sins, I am a lawyer. So the book before this was about the battle for Jewish children in Montreal to have the right to go to public school in that city, because Montreal had a very bizarre education system where you had a Protestant school board and a Catholic school board who ran all of the schools. So there were no public schools as we know them. They were all religious schools. And of course, if you were a Protestant, you could go to the Protestant school. And if you were a Catholic, you could go to the Catholic school. And you couldn't cross over. But of course, 1880 to 1910, huge influx of immigrants from Eastern Europe, most of whom are Jewish, most of whom want to improve their lives by sending their kids to school and getting them educated, so that the family can progress. It's the American and Canadian dream of immigration, right? And it's not an unfamiliar story of progress through education. But they weren't Protestants and they weren't Catholics. So where could they go to school? And this was, for 30, 40 years, this was a major constitutional crisis in Canada, because the status of these schools is protected in the Canadian Constitution. And there's no other way to get an education. So, it's an interesting history.
Where was that published?
That's University of Toronto Press.
Gotcha. Okay. So, and are do you have any future plans right now on anything, or no? Not as of now?
I do. I'm working on a book at present, which is again legal, and again sort of Jewish legal history. It's about the different attempts by Jewish communities, again, mostly in the English-speaking world, to use the court system to combat Nazi anti-Semitic publications by bringing libel prosecutions. So there are sort of famous American cases from New York, and there's an English case. There's several very famous Canadian cases, and there's the original case, interestingly enough, is from South Africa, where the Jewish community took the local Nazis to court, sued them for libel. It's an interesting sort of how Jewish communities sort of said to themselves, we are citizens of this country, and these Nazis pose a danger to us and to the democracy that is the democracy of the country where we live. So we're going to use the courts, and we're going to put a stop to them. This was before the days of, New York Times and Sullivan, and you could actually sue somebody for libel.
Very interesting. Okay, sounds great. So thank you very much for joining me. That was very interesting. I appreciate it.
Thanks very much.